I wouldn't have thought of. All right, why don't we go ahead and get started? So if you could silence your cell phones, that would be good. Before we begin, I'd like to do two things. First, I wanted to thank the ACS and specifically Miguel Pazos for helping sponsor this event and also provide some food for the lecture. So afterwards, we'll have pizza. Second, I wanted to give you guys the format of what we're going to do. First, Professor Taylor is going to speak on the early stages of the federal constitutional right. Then Professor Bastris is going to comment on the state constitutional litigation. Then Professor Taylor will comment on the revival of this federal litigation. And then Professor Lefaucheux is going to set up a different perspective, which is that of labor issue. And really what happens if neither federal nor state courts step up to enforce adequate support for education. Finally, we'll open it up for questions and comments, and we're going to try to keep each panelist to about 10 or 15 minutes, and I have time cards to make sure that that happens. So I wanted to start out with a quote from Thomas Jefferson, and he said, "An educated citizenry is vital for a vital requisite for our survival as a free people." So boy, do we have a treat for you today. We're going to talk about the right for education, the constitutional right for an education. Not only is this topic timely because of the West Virginia's teachers' strike, which I know created a domino effect for many of the teacher strikes across the country, but this topic is timely because we are seeing a wave of reforms, both good and bad, that concern education. Not just education law, but education in general. And this is important because many of these reforms could really shake the foundation of our democracy for years to come. All right, so who do we have as our panelists? We have first Professor Bob Bastris, who I think of as the samurai of constitutional law. Why do I say that? Because he lives by a code of benevolence, honesty, respect, mastery, and honor. He has literally written the book on constitutional law. I'm not joking. There are two books entitled The West Virginia Constitution and Cases and Materials on West Virginia Law. Next, we have Professor John Taylor, who is the Shaolin monk of constitutional law, right? And it's not just because of the hair, that would be too easy. It's because he is a true analytical philosopher. He has his PhD from Stanford University in religious studies. His works are meditative. He sees things clearly. He is thoughtful, objective, analytical, and fair. And last but not least, we have Professor Ann Lefaucheux. Lefaucheux, who let me do this introduction, right? For the next 30 seconds, I finally get to embarrass you instead of vice versa. So Professor Lefaucheux is the true constitutional ninja. Why do I say this? Because she fights dirty, right? So in all seriousness, first years, watch out. She is relentless in what she chooses to do and takes an unorthodox approach to find the quickest, easiest, and most efficient way to accomplish her goals. She's agile, mindful, and always prepared. Just look at what she's accomplished. Benenham Professor, Outstanding Teacher Award, Professor of the Year, Faculty Scholarship Award 4 times, a Fulbright Scholar, Harvard educated, and a PhD from Oxford. I mean, she's even got a Supreme Court case in cert. So how can you be more ninja than this? Clearly, she is just like Cobra Kai. She's swept the leg when it comes to academic prowess. Maybe that reference is a little bit before your times, but I thought it was funny. All right. So what do a samurai, a monk, and a ninja all have in common? Well, they're here to school you. So with that, we're going to start our Constitution Day seminar.
All right, thank you very much, Sean. So the introductions, which we had no screen of, may well wind up being the most entertaining part of this. Sean dissuaded us from our plan to do a 4-hour program on this, so this is going to go pretty quickly. So strap yourselves in. As Sean explained, Bob and I are going to tag team this, right? So the story of a constitutional right to education has both federal and state dimensions, and the story turns on what the difference between the two stories turns on an important fact, which is basically every state constitution includes an explicit duty to provide education, which then correlates with a right in students and families to have that education provided. In contrast, the federal Constitution never explicitly mentions education, and while the court sometimes will recognize non-textual rights, it often is a little bit reluctant to do so, and that means the path to a federal educational right has been harder. I'm going to do the first phase of it now, which is basically a story of failure, and then we'll see whether the new phase is a story of failure when I come back to that. Okay? So even though you don't have text in the Constitution, if you go back to the early 1970s when the Supreme Court first confronted this issue, there were a number of reasons why it might have been thought that the ground was fertile for the recognition of a federal right to education. Right? And so I'm going to go through 4 of those reasons. 2 of them relate to the famous decision in Brown versus Board of Education outlawing segregation in 1954. And in the course of explaining the decision, Chief Justice Warren authored a passage that I like to refer to as the hymn to education passage. Right, so it's a good bit longer in the original, but you can read through the basic basic keys of it, where Justice Warren makes what seem to us the commonsensical points that it's hard to imagine in the modern world any kid having a decent chance for success in anything without a good education, right? And connecting education to the very idea of citizenship. So that's one idea. Another idea creating fertile ground is that you can see the quest for fair educational funding as kind of a logical extension of Brown, right? Brown said within districts, if kids are going to have a decent chance, if kids of all colors are going to have a decent chance at education, schools need to be integrated. That's the only functional way we're going to deal with intra-district inequality. Well, what school finance equity does is basically say, just as we don't think that race should determine a child's educational opportunities, we don't think the wealth of the child's family or the wealth of the district in which the child resides should make a difference either. We're going to extend equity and equality across district boundaries and not just limit it to the situation within them. Third idea, I think equal educational opportunity is an important part of what I might call one of our legitimating myths. Myths not used in the sense of not true, but myth in terms of a normative story we tell ourselves about who we are, right? So we all know that among industrialized democracies, our society contains quite a lot of inequality, and we all at least sometimes think about, well, what makes that okay? And I would suggest that most of the time, most of us probably come back to something like a race metaphor, because this is America and everything has to be a sports analogy, right? So the idea is you have a race and the starting line is fair, and maybe some people get a lot farther than others, but if the starting line was fair, the fact that there are differences in outcome doesn't mean it's unfair, right? Now, there are a lot of ways in which the starting line is not particularly fair in the society if you think about it very much. But I would submit that the reason that myth works for us to the extent that it does is that we believe the right to a free, quality public education gives everybody a fair shot. And when litigation throws in our faces facts that make it clear that maybe that's a sham, it goes to the core of our ideals, and that has a lot of resonance. And then I'm going to have to give doctrine sort of short shrift in here, and most of the audience, I think, won't take common law until the spring. But suffice it to say that post-Brown, the Warren Court had a couple of lines of cases that seemed to sort of provide an easy path to recognizing a federal constitutional right to education. One of them was the idea that wealth classifications are suspicious. The other, the classifications bearing on fundamental interest are suspicious. And in light of Brown's hymn to education passage, the argument that education is a fundamental interest seemed like a pretty easy one to make. So as a result, there were a number of cases around the country, most prominently the one in California that I list up here, that recognized a federal right to education in the early 1970s. Okay? So this issue gets to the Supreme Court in a case called San Antonio Independent School District versus Rodriguez in 1973, and this case basically marks the sort of end of the first quest for a federal constitutional right to education. Like most litigation in this area, it's a tale of two districts, and so I've given you a few figures about the Edgewood district and the Alamo Heights district. Both of them were in the San Antonio area. Edgewood is much browner, much poorer, much lower property tax base. Alamo Heights, much wealthier, much wider. And if you look at the way Texas did funding, you have this breakdown. And again, what Texas did was typical of most states at the time and today, where we've got a portion of state funding, we've got local funding, which basically comes from property taxes, and then we've got federal funding, usually in the form of Title I money that's designed to kind of compensate for poorer kids and provide them with more opportunities. And if you look at the chart, it will be apparent that Alamo Heights had a good deal more money. Indeed, the per pupil allocation back in the time was only about 60% in Edgewood of what Alamo Heights had, and almost the entire difference comes from the second component, the property tax component. Is that because people in Alamo Heights cared more about education? Well, the rate at which they taxed their property was actually lower than the rate in Edgewood, right? But the property in Alamo Heights was worth so much more money that they could raise a ton more money in local property taxes than could Edgewood. And the heart of the plaintiff's case was this is inequitable, right? It shouldn't be the case that the quality of education available to a child is a function of the size of the property tax base, okay? So the Supreme Court decides this, and they rule 5-4 that the Texas scheme is constitutional. It doesn't violate equal protection. Justice Powell, who was one of 4 appointees that Nixon had a couple in the years immediately prior to this case, writes the opinion. Powell wrote a lot of education cases because Powell had been chairman of the Richmond School Board and had a keen interest in these matters. So the key question doctrinally, and again I'm going to give it short shrift, is what's the standard of review? Right? And for the 1Ls you'll learn, and you'll learn later and upper levels know now, the basic options were strict scrutiny, a very demanding standard review that it's very difficult for the state to satisfy, and rational basis, which is a very permissive standard of review. And basically in this instance, Texas had conceded that it loses if strict scrutiny is the standard. So the entire case turns on the standard of review. The plaintiffs make the arguments already alluded to the Supreme Court. They say basically this is a wealth classification, and we've said that's suspicious. Justice Powell rejects that and says in earlier cases where we ruled that wealth was a suspect classification, the wealth classification resulted in a total denial of the right. That hasn't happened here. These kids are still getting an education, even if it's not as good as the one they would like. On the fundamental interest point, he says, fundamental interest is a matter of is it explicitly or implicitly in the Constitution. You can't get a fundamental interest, Justice Powell says, just from arguing that this right is really, really important and really closely connected to other rights. So having concluded that rational basis is the standard, Justice Powell has no difficulty in saying there is a rational basis, and that rational basis is local control. This is a little bit bogus in the sense that the people in Edgewood would have said, how does this further our local control? We wanted to raise more money, but we couldn't because we didn't have enough property value in the district, but nonetheless, the court says that this is all right. Justice Marshall's dissent is fascinating. I won't go into the doctrinal aspects of it, but I wanted to just give you sort of this brief quote where Marshall is basically harking back to this kind of legitimating myth that I discussed earlier in saying, I thought the idea here was that everybody gets a fair start. And if that's the ideal in America, I don't see how we can basically let so much of a kid's educational prospects be tied to the wealth of the district in which the kid resides. There were other anxieties besides doctrine that drove Justice Powell's opinion. I'm almost out of time, so I'll just say mostly important, Powell was worried about judicial competence. If we strike this down, do we have any idea how to design funding systems? I think we don't, so we're reluctant to go there. Powell also says basically what Texas does is what all the states do. And if we're going to strike this down, there's going to be an enormous shift in power to the federal courts from state governments, and that's inconsistent with principles of federalism. So after San Antonio, the main action shifts to the state courts, and Bob's going to talk to you about that. Just 2 more little quick pieces. So one of them is that even though San Antonio rejected the idea that you've got heightened equal protection scrutiny for funding disparities and didn't recognize the right the plaintiffs put forward, it at least left open the idea that maybe there's such a thing as a federal constitutional right to a minimally adequate education. And so this passage in San Antonio, and then later in a 1986 case, the court looked back at it and said, yeah, we've always left that question open. And then jumping a little bit ahead in time, a real quick word, if I got a minute, Sean? Okay, a real quick word about a case called Plyler versus Doe from 1982. Now, this happened after Bob's story was already well underway, but it winds up being important in the current litigation. So Plyler versus Doe is a case in which Texas basically had passed laws essentially denying the kids of illegal immigrants the right to a free public education. Now, they could go to school, but they had to pay tuition of like $1,000 a year, which was real money back in 1982. And if you're an immigrant sort of struggling to get by, basically it was a non-starter. And even though the immigrants had challenged this and had won in the lower courts, it was kind of a tough case to make out under the doctrinal terms of San Antonio. You can't really say illegal aliens are a suspect class because the government has the right to draw these categorizations. And Rodriguez had said education was not a fundamental right. Nonetheless, the court struck down the scheme, applying a kind of heightened scrutiny. It's a little, some people say it's rational basis with bite. Some people say it was intermediate scrutiny. But basically, the court does three things that are important. Justice Brennan says, first of all, to deny these kids education is basically penalizing them for wrongdoing of their parents, which seems unfair. He says maybe education isn't a fundamental right, but it's no ordinary government benefit either. It's really important. And then he also basically says, if these kids don't learn to read, all doors are going to be closed to them, and basically they will be a permanent underclass, which is going to be a stain on our honor as a country, and is going to be a very real practical problem, since the reality is most of these kids are still going to be in Texas. Better that they are educated and can get a job and so forth than to basically hold them in ignorance. And so the court, 5-4 with Justice Powell switching over from Rodriguez and joining, basically says that the right to education was at least strong enough to prevent Texas from doing what it did. And with that, I'm sure I'm at 10 minutes, and I'm going to turn it over to Bob.
Okay, so Rodriguez was decided in 1973, and it actually set up what was to come. It's as John mentioned, Justice Powell, in his Rodriguez opinion, defined a fundamental right as a right that is expressly or implicitly provided for in the Constitution. And as John also mentioned, every state constitution has a guarantee for a free public education. So it made it easy for the courts and the state courts then to look to their own state constitution to say, oh, well, there's an express provision for a right of education, and therefore just relying on the Rodriguez rationale, the several courts very quickly after Rodriguez was decided construed their state constitutions to provide a fundamental right to education, most notably the California Supreme Court in Serrano versus Priest and the New Jersey court in Robinson versus Cahill. It was also right about this time that a class of plaintiffs in Lincoln County, West Virginia, filed a lawsuit promoting the same idea, that education was a guaranteed fundamental right under Article 12, Section 1 of the West Virginia Constitution, which provides that the legislature shall provide for a thorough and efficient system of education, a thorough and efficient education. And thorough, the court held, had a qualitative component to it, and it actually defined what a thorough education is. It's a definition which eventually becomes pretty important in this narrative about state constitutional education rights. That the state has an obligation to develop in every child, to his or her capacity, literacy, the ability to do math, knowledge of government, self-knowledge and knowledge of his or her total environment, work training and advanced academic training, recreational pursuits, interests in all creative arts, and social ethics. I'm clipping the definition, but basically a well-rounded education is what thorough and efficient means. So the case had been dismissed in the Lincoln Circuit Court, and the Supreme Court then West Virginia Supreme Court in 1979 reversed that decision. This is the Paulie versus Kelly decision. In this rather thorough opinion by Justice Harshbarger, the court sent the case back to Circuit Court for trial, and it appointed at the same time a circuit judge, well-regarded, highly regarded circuit judge from Ohio County, Judge Arthur Reck, to handle the trial and to rule in the case. After a long trial, he was later Justice, Judge Reck issued a 244-page decision in May of 1982, which became known as the Reck decision for obvious reasons. It detailed the number of ways in which the West Virginia public education system failed to meet the thorough and efficient standard, and imposed some rather broad-reaching remedies, which then in turn caused a wide round of hysteria in state government, as governors and Speaker of the House and the President of the Senate all condemned the decision as encroaching upon the political branches. But the state did not appeal it. So the Supreme Court never had a chance to review what has become known as the Reck decision. Instead, the state came up with what it called a master plan to try to meet the requirements that Judge Reck had set forth. Reck accepted the plan, except in two regards. One, he said it was unconstitutional for failing to provide for a parental grievance process, and because it provided for a 17-year phase-in, which he said was unacceptable, and instead imposed, it was sort of like Brown versus Board of Education, required at the implementation at, quote, the earliest practicable time. The plaintiffs appealed that and lost. The Supreme Court upheld that part of the decision. Meanwhile, this sort of national movement develops, this national movement for educational reform, and it was all pretty much aimed at the reliance in states on property taxes to finance public education. And the problem there is, of course, as John described from the Rodriguez case, is that property values vary dramatically between districts, and the ability to raise funds likewise varies dramatically. And so you had property-rich districts with a lot of money to educate their children, and property-poor districts struggling to find enough to provide even a minimally adequate education. And eventually, over the decades, I think there were 28 states in which the state Supreme Courts declared the school finance system in the state unconstitutional. There were 14 states or so, these are rough numbers as I recall them, who declined to, where the Supreme Courts of the state declined to overturn the finance system. The movement stalled in the 80s, mainly because of a political pushback from the legislatures and from local school boards. The problem was, of course, that the remedy that these early cases were imposing was basically you got to equalize funding. And because of these huge gaps in the amount of money available to the local districts, the remedy, the court said, was to provide for equal funding. And that meant states had to do one of two things. Either they had to bring the bottom up to the top level or to some medium position in between, or you had to reduce the top down to the bottom or someplace in between. And the legislatures were not willing to fund what it would take to raise the bottom up, and the local districts that had the money the wealthy, wealthy districts didn't want to lower their expenditures for education because they wanted to be able to take advantage of the money they had to provide a quality education for their children. And this resulted in basically a stalemate in a lot of states. They were just, the legislatures were not willing to implement what the state courts had ordered. Then in 1989, the Kentucky Supreme Court decided a case called Rose versus Council for Better Education, which marked a major shift in the public education finance cases in terms of the focus. The Rose decision was dramatic. It threw out the entire educational system in Kentucky. It declared basically the Department of Education unconstitutional, threw out the existing educational code, and said you need to come up with something else. So Rose was a big difference, both doctrinally, but also in the response it got. The big difference in Kentucky was that the political branches bought in, big time. The governor was very supportive of the court's decision, and eventually he got together with the legislature and they produced what's called the Kentucky Educational Reform Act, or KERA, which has been looked to as sort of a model for how to remedy some of these school finance issues, as well as delivering a quality education. And the big difference in the focus of the Rose decision was to shift from equality as the remedy to adequacy. The Constitution requires an adequate education, not necessarily an equal one, and it enabled the political branches to get past the stalemates that they had basically created. And so this major, you had the sort of the equality movement, and then you had the adequacy wave of cases. Meanwhile, back in West Virginia, the Paulie plaintiffs were not satisfied with the implementation of the master plan, so they moved in 1995 for additional relief in the case. The case was assigned to another circuit judge, and he ruled in 1997 that the state system was still unconstitutional. And the case was then reassigned back to Judge Recht, who was by now back in the Ohio Circuit Court. And Judge Recht held more hearings. There was an agreed order which resolved a lot of the remaining issues in the case. But then in December of 2002, Recht dismissed the case and observed that the legislature had what he called a long overdue educational epiphany, that it had in 1998 enacted a new approach to education which emphasized not inputs, but performance models, outputs, if you will, and had created a system which held local districts accountable, held accountable through annual audits of what kind of outputs they were producing, and if they didn't meet the state standards, the state could move in to take control, and the state has taken control in, I believe, about 6 or 7 different counties over the 20 years since the 1998 Act. So the Recht decision did not end up mandating equality, but said that basically the legislature's new approach should be given its chance to see if it would work. It's essentially the same principle as No Child Left Behind, which has its critics, but nevertheless, that's what the state has opted for, and there has been no reopening of the Paulie litigation. Paulie was a success, and this is probably true in a lot of states as well. In some ways, it was successful. It significantly had the effect of significantly increasing state funding and support for public education, that we went as far as we could in achieving equity. We couldn't go the whole way because we have something called local excess levies, which affect the equality aspects of education in the state, but we still are about third highest in the country in achieving equity. Only Hawaii has perfect equity because it's one school district. So it's equal for everybody. But we do as well as we can within our constitutional property tax system. We have, Paulie resulted in much greater emphasis on state support and a de-emphasis on local property taxes. And West Virginia remains very high in the percentage of its budget that goes to education. It's still about average in terms of per pupil expenditures, but in terms of percentage of state budget, it's very high. And it's also resulted in a more centralized financing of school construction, was probably the biggest effect of Paulie. One of the things that the Paulie decision required was that the state have a centralized financing plan for funding school construction. And as of 1988, when that bill was passed, schools in West Virginia were in horrible physical condition. I mean, it was just terrible. And all of the counties needed major reconstruction. So the legislature created the School Building Authority, and then we have a centralized financing system for the construction and repair of public schools. And that had some unfortunate side effects, but certainly the positive side effects is that our school buildings now at least are physically solid. The one thing that Paulie has not produced, unfortunately, is any significant increase in the in our test performances as public school students. Those remain pretty low compared to other states. So there's been some positive effects coming out of Paulie, but not all that we had hoped to achieve or that the state had hoped to achieve. And the national movement has pretty much shifted its focus then to the adequacy realm. And some states have even gone to actually having sort of a reverse educational formula. In like New Jersey, for example, in the Abbott decisions, New Jersey Supreme Court has ordered additional funding for school districts in particular need. They're called the Abbott districts, and they're primarily concentrated in poor urban neighborhoods. So the educational reform movement remains alive, but it's at least at a level plane at the moment. So go back to you.
All right, so thank you, Bob. So Bob has done a great job of walking you through some of the state story. Every state has its own story. West Virginia's story is particularly interesting and illustrative, and Bob has given you a fair amount of detail on that. So I'm going to come back and talk about kind of contemporary developments on the federal side. And one thing you might fairly ask is, given that my earlier story was one of failure and that Bob's story is one of some, not a success across the board, but some non-trivial success, why would the federal right be coming back, and why would there be some recent federal right to education litigation? And so I want to sorry, I should have done that before. I want to suggest a couple reasons why, right? So in West Virginia, we did pretty well. Not everything that had been hoped, but we got pretty far. In some states, the movement to use state constitutional rights to education never really got off the ground. There were a number of courts that basically said the duty to provide education is committed to the legislature. If we, the courts, muck around in that, we're violating the separation of powers, so we stay out. Other states said, we do think that there is some right to education and there's some judicial enforcement, but they defined it so very minimally that it didn't provide much leverage that plaintiffs could use to sort of get greater educational equity. My point B is that even in a lot of states where the courts recognized a state constitutional right that had real substance, and again, as Bob said, when the theory sort of moved to more the state constitution guarantees an adequate education of a certain sort, litigation tended to be more successful. But in many of these instances, what would happen is the court would demand something and the legislature wouldn't necessarily do it. So sometimes the legislature would say, we're striking your system down, go back and try again. The legislature would come back. In the New Jersey litigation, I think that case has been to the Supreme Court 20 times, I believe, over the course of decades, right? And in a lot of these instances, at a certain point, the courts decide that they've kind of gotten what they're going to get, and they throw up their hands. In a lot of ways, that's what happened in West Virginia. At a certain point, the court sort of decided that it wasn't going to get any more change from the legislature, and it declared victory and went home. This has been particularly a problem since the Great Recession because when everything went to hell in 2007, 2008, lots of states slashed their education budgets, and in a lot of states, those budgets have never come back. So there are a fair number of places where really the state courts have not been able to provide that much relief. And so if you feel like you just can't get what you're looking for from the state constitution, you may seek to use the federal constitution instead. A third point is that whereas state constitutional litigation has to focus only on intrastate inequities, right? The reality is interstate inequities in educational opportunity are at least as big a deal. Right? And if the idea is that the child's zip code should not determine his or her access to a good education, that same point would seem to be true whether the two zip codes are two different places in the same state or whether one zip code is in one state and the second in another. So that's a reason why a federal constitutional right might seem attractive, that it would give you better leverage to address interstate inequities. There's been, one questions how much scholarship drives these things, but there's been some very interesting new scholarship trying to sort of build on theoretical approaches that might resurrect a federal right. And some of the complaints I'm going to tell you about, that scholarship has gotten some traction. And then probably at the time when these recent suits started, there was hope that we were going to have a Democratic majority on the Supreme Court for the first time since, late 60s, I guess. And so, because everybody assumed that Hillary would win and Garland would be the fifth person, and obviously it didn't work out that way. So these federal cases are going to prove to be a lot harder to win than maybe was thought. So let me tell you just a little bit about two recent cases, and mainly the Detroit litigation to save time. Both these cases are sometimes described as next generation cases because rather than seeking the relief of let's restructure the entire education system, as Bob described in Kentucky, or let's restructure the entire finance system, these complaints seek more focused kinds of relief, and they're not just about money, and the thought is maybe courts are going to be a little bit more willing to grant that kind of relief. So there's litigation in Detroit that's often called the right to literacy case. The case is called Garrity versus Snyder. It was filed back in 2016. Why are we in federal court? Basically because Michigan's constitution had been read in this decision not to really guarantee any qualitative right to education. If you look at the language from Michigan's constitution, it doesn't include those terms that Bob mentioned, like uniform, thorough, efficient public schools that have been taken to mandate a qualitative standard. And so the Michigan state constitution has been read to basically say, you got to give kids a school, but even if it's a really crappy school, the constitutional obligation is still met, right? So in light of that litigation, the next stage in this case was to try a federal constitutional argument. If you want to learn more about this, there's a website devoted to the case. You can read the complaint, which is 136 pages long. And if you read it, the gist of it is that Detroit has had a lot of financial and educational problems over a long period of time. The state has basically been running its schools for the past 20 years. The schools are overwhelmingly high poverty and high minority. The reading scores are abysmal. The facilities are abysmal. Tiles are falling off the roof during class all the time. There are rats and bugs all around. The textbooks they don't have enough textbooks to go around to all the students, so it's hard to assign homework. The textbooks are really old. They can't control the temperature in the building, so when it's hot, it can be 95, 98 degrees in the classrooms, which makes it pretty hard to concentrate, etc. So the whole thing is kind of a horrifying description of conditions. A couple pictures from the complaint. This is the World History book. It's seen better days. And when was it published? Answer, in 1998. Okay. And then you've got this. Those are cockroaches if you can't see them. Mice are everywhere. So basically, the complaint, I think, fairly says, you know, if this was kind of a suburban district, nobody would tolerate this for even a moment. And so basically, the theory of the case is there is such a thing as a right to a minimally adequate education. If you can't at least read, you have no chance of any kind of success whatsoever. They draw on the language in Plyler versus Doe. A lot of people, after the complaint was filed, it's got some high-profile law professors on the brief, and the argument was no court could possibly turn this down, but in this decision, the district court in eastern Michigan, the federal district court in the Eastern District of Michigan did turn it down. It's on appeal to the Sixth Circuit now. We will see what happens. There's other litigation in Connecticut, which I don't have time to talk about. So now the question is, if you can't get real educational support in federal court or state court, what options do you have left? And the option is public action, and Professor Lefaucheux is going to tell you about that. You have to wait while Ann prepares to shame me with her PowerPoint, yes, and make me look like the Neanderthal kindergartner in this regard that I am.
I apologize. Is there a clicker, or do I have to use this?
Oh, I'm sorry. I stole the clicker.
He was trying to make me look bad. Professor Taylor.
It's a vain effort.
I see. Professor Tu said that I'm the one who plays dirty, but it's really Professor Taylor. Anyway, welcome everyone. I'm Ann Lefaucheux. I'm a professor here. I teach labor law, employment law, and jurisprudence. Many of you haven't met me yet because I teach upperclassmen and women. But I'm here to talk to you about not really about the constitutional right to. It's not working though. It's working on here, but not on. We just need, we need some technical assistance. No, it's not your fault. There we go. Is that going to work now? Yeah. Okay. There we go. So I'm going to talk about the teachers' strikes. And I think that Professors Bastris and Taylor gave us a really good background to understand really why the teachers went on strike, or at least part of why they went on strike. So here we had a wave of teacher strikes. There were 6 of them this year. Chicago had one a few years ago, and then also again 4 years before 2016. But we see that it started in West Virginia, right here. It went to Oklahoma, Kentucky, Arizona, over here, Colorado, and North Carolina. So we had, and you could see how long the duration of these strikes were. Now, all strikes start with a grievance. And the question here is, what was the grievance? It's usually over pay, benefits, or working conditions, but sometimes it's over something much more exalted. Now, let's just look at the pay first. In the red, what we see is this is how much money in the states where, this is the average teacher pay in the states where there was strike action. And you can see West Virginia is really low, $33,000. There was, Oklahoma was lower. There weren't that many, only 2 states with lower than that were, let's see, Missouri and Montana were lower than the lowest. And look, Missouri is only about $100 lowest, so it's really the same as Oklahoma's. And then there's a few more in the 34,000s. So these states all went on strike in part. They have poor pay. And West Virginia, when they went on strike also, the teachers are staying here, but their neighboring states make a lot more money. I think let's look at average pay. We can look at Pennsylvania, look at that, is $44,000. So this is important. If you think about it, if the market works, which generally the market works, there are some market failures, then people would probably prefer to move across lines. And usually you hire your better teachers, so better teachers might be willing to go across lines. We're very fortunate that many good teachers do stay in West Virginia because they're very dedicated and loyal to West Virginia. Having said that, this seems pretty unfair. These are teachers' pay unadjusted for inflation over the past 15 years, and they have gone up, but of course inflation has gone up. So what we really want to look at is adjusted for inflation. And by the way, the red is West Virginia. So you can see that it's fairly flat. And this is public school funding since 2007. And what you see is that federal funding is pretty much at the level of the pre-recession level. But state funding has gone a little bit down, and this has put increased financial pressures on local governments. And local governments often they need to raise that revenue somehow, usually through some sort of property tax that Professors Bastress and Professor Taylor were talking about. But as we know, the problem with using property taxes is that people in richer areas will have better school districts because they can spend more money, because they have more assets and more resources. And West Virginia's teachers' strike was a statewide 55-county teachers' strike. This is amazing. It lasted for between the late February to early March. It shut down every public school in West Virginia, every single one. 34,000 workers walked out. They were in total solidarity. In fact, more workers would have walked out, but the teachers told the teaching assistants, the substitute teachers and people like that, not to walk out, not to risk their jobs. This was their fight, and they were going that the teachers' assistants and the more peripheral teachers would be able to help in the future. But right now, let the teachers who've been there fight this battle. So incredible selflessness, incredible solidarity, and a lot of this done through social media. Now, there were 5 demands. We often hear about pay and benefits. We hear a lot about PEIA. PEIA, trust me, it's my health insurance as well. It is a mess, and it is being. Professor Tu is actually on one of the committees that's trying to fix this. It's a major problem. Health insurance, as you know, is a major problem in this country, and healthcare is very expensive. But here are the other demands. Stop the expansion of charter schools. Stop proposal to eliminate seniority. Stop Paycheck Protection Act. Let me talk to you about Paycheck Protection Bill for a second. A Paycheck Protection Bill, its only purpose is to hurt unions. Because what it is it says that you can't take union dues out of a paycheck, which means it's very difficult for unions to raise money. And there's the employer, which would be the government, there's no cost to the employer to do this. So why do it? The only reason to do it is to undermine the right to organize. And that's actually a constitutional right in West Virginia. And if you think about it, it should be a constitutional right no matter what if you are in the public sector, because there's state action. Most of you don't know what state action is. You will learn about that next semester. And I'm not going to go into that unless you want to take my jurisprudence class, and we do talk a little bit about this. But this is a major problem when you think about the right to organize, the right to gather together, to present your grievances to a government. Well, why isn't this being protected? Then there's also the higher pay and the mechanism to fix health insurance. Now, you could see that the teachers were very, very patient for many years, but they're very underpaid, and their main chant was public education in West Virginia is not good enough. And therefore, the parents were in solidarity. I am the parent of a high school student. She didn't go to school during this time. And we were in complete solidarity. We baked cookies. My daughter's a vegan, so my daughter baked vegan cookies for all the teachers online. We did things to support them because it's true. They are giving of their time, and they're not sometimes making enough money. Even they have to take second jobs so that they can support their own families. And here they are teaching our children. Then there was this wave of strikes, like Oklahoma teacher strike. This is what they won with just the threat of a strike. $6,000 average raise this year and added nearly $500 million in educational funding. After the strike, the legislature passed several other revenue increases to benefit education, including a new tax on online sales and an expansion of the type of games permitted at casinos. This is notwithstanding the fact that Oklahoma had a supermajority. You need a supermajority in Oklahoma to raise taxes. So this is incredible. Supermajority, 75% you need in Oklahoma. So this is incredible that people willingly, they voted for an increase in taxes because of this. Kentucky, their demand was, again, for more funding for public education. And look what they did. They said, we will remember in November, fund public education. Republican lawmakers overrode the Republican governor's veto of this. And the Dems sided with the governor because they felt that there was a tax was going to harm very poor people. That's what they were concerned about. I just want to go back for a second because I just want to show you something here. Look what this sign, this is in West Virginia. Maybe you can find money in the $32,000 couch cushions to get out of this mess. I think this is really important. When you have morality on your side, when you have public officials acting in a way that doesn't seem right, and they're spending $32,000, that is, by the way, let's look how much the average school teacher makes a year. Let's in West Virginia. Oh, look at that. About the much to buy a couch for their living room. I thought that was going to get a laugh. Didn't you think that was funny? God, I thought that was a good joke. All right. But it is, right? I mean, a couch if you're, okay, I won't say who. Okay? This is really important. Well, now watch this one. I just want you to hear what the Kentucky governor's response was to the strike. This is great. Hopefully, this is on. Because I want you to hear it in his voice. Ken, I need you. Ken? Calling Ken. He's the best. Thank you.
Oh, shit. Since it's in this form.
If it doesn't work, I thought it might not work. I do have, that's okay. If you want it, I'll give this to you. But the good part about it is I decided to quote it just in case. You know how many, this was his response, do you know how many hundreds of thousands of children were left home today, alone today? I guarantee you somewhere in Kentucky today a child was sexually assaulted that was left at home because there was no one there to watch them. I guarantee you somewhere today a child was physically harmed or ingested poison because they were left alone because a single parent didn't have any money to take care of them. Obviously not getting the point, okay? Big backlash against this guy now, right? This is going to go into my law review articles also, right? And everyone else is writing about this. So now he has to live with this. This is what his legacy is. Here, the Colorado, they closed down 10 of 181 school districts. I couldn't find out what percent. That could be a lot or a little. I don't know. Their demand was, again, more funding. The Colorado underfunds schools by $822 million annually. $820 million annually. The new president, Carrie Dahlman, she said that's $6.6 billion since 2009. $6.6 billion since 2009. Undercutting education, underfunding education. The response look at one response. 2 state senators proposed a bill that would fine teachers $5,000 per strike day and jail teachers 6 months for striking. Now, if you take my labor law class, this is going back 100 years, more than 100 years, when we actually use criminal laws to repress this type of activity. So they're trying to criminalize complaints about our children that are really important, that not only is there potential, there's this constitutional, or we would like this constitutional right to an education that we're pushing for, there's also constitutional rights to complain about our government. But even if they're not, right? Even if they're really weak or whatever, there's moral rights to this, right? And they're trying to criminalize this. I want you to really understand that. It's important. Here we have North Carolina, and they said, this one I like, some cuts won't heal. I really like that one in North Carolina. They complained that the Republican-controlled state legislature slashed corporate taxes and cut education budgets. And that's pretty much the complaint. Not always, it's sometimes the Democratic legislature. Here it was Republican legislature. But the complaint is that why are you slashing corporate taxes, but you're also cutting educational budgets? It seems there's something wrong with this picture. I just want to give you a little bit about the larger picture here. I'm going to on three things. First, underfunded pensions. So one of the big problems that that state officials have tried to make unions a scapegoat about is something called underfunded pensions. So just by way of background, in the 1970s, when we were funding more pensions, we did something called defined benefit plans. That meant when you retired and you were all done, that when you retired, you would get a defined benefit. Now that's really good if you're the worker, because you know exactly how much your retirement benefit's going to be. If you're, and you don't have to take any market risk. So you don't have to invest your money, and worry about that, because the market risk is all on the employer. The problem with it, everyone thought this was a great idea. Everyone thought that was wonderful, because everyone thought the market just goes up, 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 and we are the greatest nation in the world, and everything was just going to go perfectly. It's sort of a Whiggish history of America, thinking that everything was just going to keep on going up. And the problem is we have stock market crashes. So because of these stock market crashes, now the pensions are underfunded. Well, who did they blame? They blamed the unions. Even though unions took pay cuts to get these defined benefit plans, and even though it was for everyone, it wasn't just for unions. So public officials did this thinking that this was going to actually line the budget. It was going to line the treasuries, the state treasuries. But when it didn't work out, they blamed unions. And unions don't even, in many states, in most states, don't even have bargaining rights over pensions. Very few states have bargaining rights over pensions. I think California is one of them. So it can't even be their fault. So this is what happened, was that now the states were really, their budget was really, really hurting. And we saw the beginnings of attacks on unions. And that's when you saw the Scott Walkers and the Wisconsin governor and the different governors, the governor from, even from Ohio, were starting to attack public sector unions and do things to really repress union activity. Well, I'm telling you, when you repress something as fundamental as freedom of expression and freedom of association, you're going to get a backlash eventually. More repression. Janus, this is my last point. Janus is a Supreme Court case that just came out, and it's basically this idea that all right-to-work statutes in the public sector, that all states are now right-to-work in the public sector. Now, one thing about right-to-work, because you hear about that in the news a lot, people will tell you that without a right-to-work statute, that you will be forced to join a union. That is not true. Anyone who tells you that is either ignorant of the law or lying to you. In this country, you can never be forced to join a union. That is the law, even before Janus. The only difference between a right-to-work state and a non-right-to-work state is whether or not you pay no dues for representation or you pay some dues for representation. And those some dues are only about for the grievances and collective bargaining. Political activity, you never have to pay for unless you want to pay for, ever. So that's a very important thing to understand. This attack on unions I'll finish up now, has caused, I think, this repression, which is bottled up, and we are seeing now that people are very organized. and will continue. There will be more strikes, and let me predict there will be more strikes in West Virginia itself. Thank you very much.